Hello, this is Stephen Bonfa. This presentation is on estate planning fundamentals. It's January of 2023, so some things have changed. So I wanted to give an update, but this should give you some basic idea of what goes into an estate plan. So when you speak to your attorney, hopefully it's me, you can have a basic idea of what goes into it and some questions that can you can fine tune to figure out what you would like to do. So there are three basic things that I look for when I speak with clients. Where do they want their stuff to go to? Whether or not there's an estate tax consequence, and whether or not Medicaid and asset protection is something that they are interested in and is a priority to them. You can dictate where your assets go by either naming beneficiaries to accounts. You can change title or ownership. You can make specific gifts during your lifetime as well as after you pass. You can name things in a residuary clause and a will. You also have to keep in mind that if there are certain people who you do not want to get your assets after you pass, this is something that we can also do in an estate plan. So the threshold before there is a inheritance tax at the federal level is $12,920,000 in 2023. In 2026, however, this law sunsets, so we don't know what it's going to be in 26, which is why we like to recommend every 3 to 5 years, we should be reviewing your estate to make sure that it doesn't have any consequences. New York is less than the Fed in 2023. If you have under $6,580,000, there is no estate tax consequence. However, New York has what we call a fiscal cliff. So if you're more than 5% off the exemption, you're not going to just be taxed off the overage, whatever is over the $6,580,000. You'll be taxed from $1. This can have some really, really dire consequences. If that is you, we have to do some planning. Speaking of which, there are some things that we can do to help reduce or eliminate estate taxes. There's a credit shelter trust. This allows a spouse to hold and keep their exemption so it doesn't get wasted at the death of the second spouse. If what's pushing you over the limit is life insurance, we can create a life insurance trust. So while the receiver of the life insurance does not get taxed typically, if a life insurance payout does enter into your estate tax situation. So you as the giver, it could push you over the threshold. Again, there's annual exclusion gifting. The current amount is $17,000. There's charitable gifting. And if you're so charitably inclined, there's a private foundation. So Medicaid planning is also a big part of what people ask me for and about. In 2023, the monthly income is for a single person is $1,563, and if you're a couple, it's just over $2,100. Asset-wise, if you're single, it's $28,133. If for couples, it's just under $38,000. So if you are someone who has some difficulties, there are 7 daily activities. Can you clean yourself? Can you walk around? Can you do shopping, etc.? You need assistance, and you want Medicaid to come in and pay for that assistance. In order to apply, Medicaid will look back at all the transactions you've made within the past 5 years for a nursing home, and any transaction that's made in that time period, Medicaid will assume you made that in order to qualify for Medicaid. If you need a home health aide, someone to come into the house and help you, currently in New York, there is no look back period. That'll change in March 31st of 2024. New York passed a rule that said it would look back 2.5 years or 30 months, but they've suspended that. After 2024 in March, what's going to happen? We don't know. But as of right now, they suspended that 30-month look back period. So you can make a transfer and become qualified for health aid pretty immediately. You can spend down to get to the threshold or underneath the threshold by paying off debt, by purchasing medical devices that are not covered by insurance. You can make modification or repairs to your home. You can make repairs or modifications to your vehicle. You can purchase a specific type of annuity we can talk about. Or you can have a prepaid funeral expense or an irrevocable funeral trust. These are all ways that are allowable to spend out and get to the threshold. There are several estate planning documents that we implement here in our office to make people's plans reach their goals. First is, as we know, is a last will and testament. There's something called a revocable trust. There is an irrevocable trust, and there's some other planning methods. The components of whether you have a will or a trust are essentially the same. The beginning portion is an introduction and has your residency. You can make specific gifts. So if you have charities that you'd like to give to, you can make those. And you have personal property bequests. So if you have items that you have sentimental value for, or otherwise you want to give to some specific people, antiques, your baseball card collection, comic books, etc., jewelry, you can do that in your whether a will or a trust. If you have real property, you can say where that goes. It goes to my favorite attorney. It goes to my sister. It goes to my child. It goes to my wife. Then everything that's not already been given out falls into your residuary clause, and we find that most of the time, most of the estate gets distributed through a residuary clause. In New York, you have to be at least 18 before you can collect money or inherit money. So, however, I have young children, and I don't know if I would trust having $1 million go to an 18-year-old. So you can actually set that age of majority to be anything that you want: 18, 25, 30, 28, etc. You name your fiduciaries. Not only do you name who will be your executor, but if you have minor children, you do want to name who the guardians are. You also list the powers of the fiduciaries, what they can do, what they can't do. There are other provisions. For instance, if you have someone who has a disability and they're on government assistance, you can have a supplemental needs trust for them. Or if you're concerned that someone's addicted to drugs or alcohol, you can have provisions with regard to that. Then there's an execution, a signature, and a self-authenticating witness affidavit. These are the essential components of what goes into a will. So let's talk about the differences between a will and the trust. A last will is flexible. It could be amended at any time. It could be revoked. You can do estate tax planning. You can say where your property goes. And typically you find this the least expensive drafting to do for a client. However, some of the disadvantages, you do have to go through a court proceeding. It's called a probate proceeding if you have a will. There are delays to distribute assets. The court will not allow complete distribution for 7 months after the executor is appointed. And New York, we've been finding some major delays due to what's occurred in COVID. So I've had clients who are waiting 24 months before they can close the estate. And it does not give you, a will does not give you asset protection from Medicaid or otherwise. There's something that we call a revocable trust. You get the same benefits of a last will. It's flexible. You can do your planning in it. The biggest plus is that it does avoid probate. It does allow for fast distribution. You don't have to wait for 24 months. You can have it done much, much earlier. You retain control of the items. And if there's a disinheritance, you may want to consider that the revocable trust, it is harder to contest. There's no notice requirements. It just happens. Some of the disadvantages, it's more expensive to create than a will. There is no asset protection for Medicaid, much like a last will. The items are yours. It does not provide you those protections. You'll find year to year there's higher administration costs, either your person can get commissions, your trustee can get commissions, and you'll have some costs year to year that's a little higher, as well as there's potential loss of basis adjustments upon your death. There is an irrevocable trust. Typically, we see this in a Medicaid asset protection, although there are other irrevocable trusts. From a Medicaid asset protection standpoint, it's the same benefits of irrevocable trust. This avoids probates, fast distribution. However, you do not remain in control. You have a limited liability to amend. There is a loss of control. Your trustee is the person who is the person in charge. Assets cannot be used to your benefit, cannot come out to your benefit. Income does, but not the asset itself. And again, there's a potential loss of basis, which is a capital gain situation. With regard to life estates, this is where you change title. So you put the title in a child's name or another person's name, and you retain a life interest. So you're the boss of the property while you're alive, but the owner is someone else. You cannot be evicted. You cannot be charged rent. No one can get a mortgage or sell the property without you. You're primarily responsible for the building. So you have to paint or pay the lawnmower person. That comes from you. You have all your property tax discount. And when you pass away, you do enjoy a bump up in basis, so a reduction in capital gain or elimination, depending on the situation. After 5 years, it is exempt from Medicaid. This is a big bonus. Some of the disadvantages are, much like the person cannot sell or get a mortgage, you can't do it without the title owner's permission and agreements. It's much more difficult to get a mortgage or a reverse mortgage or things of that nature when there's a life estate on the property. Your children now have assets, so now your children or the title owners, their creditors can reach the value of the home. If you sell the property while you're alive, you have no basis adjustment and there will be capital gains. And from a Medicaid perspective, if you tend on moving and selling, this is not a good plan for you, because after a sale, that 5-year look back period will begin again. Some additional documents that we include, and certainly in my estate planning package, where there's a trust or a will, is a healthcare proxy. That allows you to pick someone to make your medical treatment decisions in the event that you're unable to make them yourself. A living will instructs your healthcare proxy as to the type of treatments that you want or you don't want in that event. So if you have a severe medical event, you have in a persistent vegetative state, and there is no hope for recovery, you can say, remove that. I do not want to be kept alive by artificial means. Or you can say, I do want to be kept alive. It's whatever your choices are. Then there's the power of attorney. Power of attorney allows you to pick who will make your financial decisions. So a healthcare proxy is health, power of attorney is financial. They can either be start that power immediately, or they can do what we call a springing power of attorney. A doctor would have to certify that you are unable to make those decisions, financial decisions, and that's when the power springs to life. In 2022, we saw some significant changes to the power of attorney. The form itself looks different. They eliminated the statutory gift rider. The default gift allowance is now $5,000. Is increased record keeping requirements, etc. I've been advising clients that if you have a power of attorney, let's get into the new form, so there's no delay or issues with financial institutions in accepting the power of attorney. So hopefully you found this little presentation to be informative. If you have any questions, please feel free to contact me. Happy to speak with you. You can either give me a call, send me an email. Hopefully you'll visit me on TikTok or Instagram at Casual Lawyer. And there's my website. And if you go to my website, you can register, and then you can watch this video as many times as you like. This video, I'm an attorney, so we do have a disclaimer. This presentation is intended to inform, not to advise. So this is a very general video. You really need to speak to someone about your specific needs and goals, and speak to that attorney, hopefully me, and we can help you get to where you want to do. But you can't rely on this video for your specific situation. All right, thank you very much. Hopefully you found this to be informative. I'll be looking forward to speaking with you. Please have yourself a great 2023.